Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. Welcome back to our video series entitled DB's Wishlist.
Hi, I am Shelley Schmitz, designated broker of Keller Williams Premier Partners here in Vancouver, Washington. And Annie, I have a question for you. When a buyer has a Form 22A financing addendum in the transaction and their loan is declined, but they still have a couple weeks before closing, can they use the decline letter from the first lender in case they don't get the second loan closed in time? I think they can, but listing brokers who are surprised to learn that buyers switch lenders argue that buyer waived the financing contingency when they switch lenders. Will you clarify, please? Thank you.
Thanks, Shelley. Short answer is yes. Buyer can use the first decline letter, the decline letter from the first lender, to recover the earnest money based on Form 22A, the financing contingency, paragraph 5. Paragraph 5 regulates the question of whether or not a buyer who terminates a purchase and sale agreement based on the financing contingency, or let me say it differently, a buyer who seeks to recover their earnest money based on the financing contingency, because it's important to remember that buyer's request for recovery of the earnest money could come after the failed closing date. Buyer isn't required to, quote, terminate the agreement prior to closing in order to recover the earnest money based on the financing contingency. But buyer must provide this lender letter. The lender letter covers 3 topics. It has to show the date of loan application, which must be within 5 days of mutual acceptance. The lender letter must prove that buyer had sufficient funds to close a transaction. And then finally, the lender letter has to identify the reason that lender was unable to timely provide funds for buyer's closing. Without this lender letter, buyer can't recover the earnest money based on the financing contingency. But with that lender letter, buyer is entitled to recover the earnest money so long as the lender letter complies with the buyer's stated loan parameters. For example, the amount down, the type of loan, etc. Okay, set that aside for a minute. What Shelley's asking is this. Let's say that buyer has a 45-day close period, about 45 days from mutual acceptance to the agreed closing date. And on day 20, for example, buyer learns from the lender to whom buyer made loan application that buyer's loan is declined. Buyer collects the paragraph 5 letter from lender at that time. Buyer still has 25 days prior to the closing date. Buyer says to themselves, hey, I'd still really like to buy seller's house. I'd like to try with a different lender. I think there's a reasonable chance I can get this property if I apply with a different lender. If buyer applies with another lender after already receiving a decline letter, Shelley's question says, if buyer is ultimately unable to get the loan from the second lender, can buyer use the decline letter from the first lender to recover the earnest money? And the answer is yes. What this question really illustrates is the importance of a listing broker and seller staying aware of what's happening in a buyer's loan. Because many of you are likely to say, that's not fair. How come the buyer can use 25 more days of this closing period to try and get financing when they already know they've been declined once? Don't they have an obligation to tell seller? And more importantly, isn't that switching lenders, which we all know buyer is prohibited from doing under the financing contingency? And the answer is simply, it's not switching lenders. They didn't switch lenders. To switch lenders means that you start with one and then you get rid of that one and switch to another one. Buyer didn't do that. Buyer started with one and went all the way through the process with one and was declined for the loan. And then buyer made a new loan application because buyer still had time to do that. Where the failing would come in a scenario like this is by the listing broker and the seller who failed to know that that happened. Listing brokers, you got to make sure that you're advising your seller to deliver the 22AP consistent with paragraph 2 of Form 22A, the financing contingency, timely. With that, buyer must return a 22AL, identifying the lender to whom buyer made loan application. And then listing brokers and sellers, it's up to you to stay informed as to the buyer's financing progress. So that if this scenario played out, listing broker would know that buyer's initial loan was declined, Seller could then deliver the 22AR in a timely manner. If seller was not willing to wait for buyer to try to get another loan with a different lender, then seller could deliver the notice of right to terminate. If buyer's not confident in that new loan attempt, buyer may choose not to waive their financing contingency, at which time seller could terminate the transaction and try to find another buyer, or maybe sell to a backup buyer if that's the case. To have any other answer to Shelley's question means that we penalize a buyer who not only tries once but tries twice to get financing to purchase the property that buyer is under contract to purchase. Our forms don't call for that punishment to a buyer. Instead, our forms create the opportunity for listing brokers and sellers to not be surprised to learn later that a buyer's loan was declined 20 days in to a 45-day closing. If listing broker and seller are doing their job, they won't be surprised. If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.